The clock is now ticking for the most powerful law enforcement agency in America. A federal judge has given the FBI a hard deadline. Not a suggestion, not a request. A command. 14 days. That's how long the Bureau has to explain why it is still hiding thousands of pages connected to Jeffrey Epstein. And this is not a routine paperwork dispute. This is a direct confrontation between the judiciary and the FBI's culture of secrecy. When a federal judge draws a line in the sand against the FBI, it means something extraordinary is happening behind closed doors. Because courts rarely corner agencies like this. They negotiate, they defer, they delay. But this time, the judge didn't blink. The order is simple in wording, devastating in implication. Explain, page by page, why these documents must remain hidden. Not in theory, not in generalities, not with vague claims of national security. Explain each one. And that changes everything. For years, requests for Epstein-related records have vanished into bureaucratic silence. Journalists, attorneys, and victims' advocates have asked the same question again and again. What did the government know, and when did it know it? The answers never came, until now. Court filings reveal that the FBI originally claimed it held only a few thousand pages. Later, under pressure, that number grew, and grew, and grew again. Now it stands in the tens of thousands. That alone raises an unsettling question. If these files are harmless, why hide them? Inside legal circles, the deadline is being described as a stress test for institutional truth. Because once an agency is forced to justify secrecy one page at a time, excuses collapse, patterns emerge, contradictions surface, and behind every sealed page is a story, a conversation, a warning, a missed chance. This isn't just about Epstein anymore. It's about whether power can still be questioned, whether silence can still be challenged, whether truth still has leverage in a system built on delay. 14 days. That's all that stands between the public and one of the most guarded archives in modern American history. And whatever happens next, someone is about to be exposed. The FBI says these documents are too dangerous to release, too sensitive, too complex, too harmful to national security. But the judge isn't buying it, because secrecy only works when no one asks why. And now, the court is asking, loudly. According to filings, these records include internal FBI communications, interview transcripts, and surveillance materials stretching back decades. Not summaries, not headlines, raw material. The kind that shows what agents saw, what they heard, and what they decided not to pursue. That's what makes this moment different. For years, the Bureau hid behind a single shield. Ongoing investigations. It was a magic phrase. A curtain. A wall. But time has eroded that defense. Epstein is dead. Cases are closed. Files are archived. And still, the doors remain locked. Legal experts say that's why this deadline matters. It strips away abstraction. It forces specificity. Every withheld page now needs a reason that can survive judicial scrutiny. Not fear, not embarrassment, not inconvenience, a real, lawful reason. And that's where institutions become vulnerable. Because systems built on opacity rarely track their own justifications. Decisions made in haste. Classifications rubber-stamped. Memos marked restricted without explanation. Those habits work until someone asks for receipts. Behind these files may be names, timelines, internal debates. There may be evidence that warnings were ignored, that leads were buried, that influence quietly redirected attention away from powerful people. And if even a fraction of that becomes public, the narrative collapses. This isn't about conspiracy, it's about accountability. If the Bureau did everything right, transparency will confirm it. But if it didn't, then these pages become a mirror showing where justice hesitated, where authority blinked, where silence protected more than it served. The deadline isn't just legal, it's moral. And institutions fear moral deadlines more than legal ones, because laws can be negotiated. But truth eventually demands a witness. Inside the FBI, this isn't being treated as paperwork. It's being treated as a threat. Emergency meetings, legal briefings, damage assessments. Sources describe a building under strain, not because of what might be revealed, but because of how much. When an agency controls a narrative for decades, exposure doesn't arrive gently. It arrives in fragments, contradictions, screenshots, footnotes, margins. It unravels. Every document carries history. Every redaction implies intent. Every gap becomes a question. And questions multiply. Some officials reportedly want to comply. They believe partial release could rebuild trust. Others argue disclosure would destabilize ongoing work, embarrass leadership, and invite political warfare. But the judge's order changed the balance of power. This is no longer internal. Now, every excuse will be read by a court, every claim tested, every silence challenged. And something else is happening. Former agents are speaking. Quietly, carefully, but with purpose. They say this level of resistance only happens when the files contain more than routine errors. They say agencies don't fight this hard unless what's hidden contradicts what was said. Because mistakes can be explained, patterns cannot. If the documents show that intelligence existed long before action was taken, the story shifts. It becomes less about one criminal and more about a system that hesitated while harm continued. That's the nightmare scenario, not a single failure, a structural one, the kind that doesn't disappear with a press conference. And that's why this deadline feels different, because for the first time, the FBI is being asked not what it did, but what it chose not to do. And that is a far more dangerous question. While institutions argue, others wait, not for headlines, not for spectacle, for answers. Epstein's victims have spent years watching documents disappear behind seals and stamps. Each denial told them the same thing: your story matters, but not enough. They were told investigations were ongoing, then that they were sensitive, then that they were classified. Every delay became a second injury. Because time doesn't heal when truth is withheld. Attorneys representing survivors say these files may finally explain why warnings went unheeded, why patterns weren't connected, why justice arrived so late. For them, this isn't about politics. It's about recognition. Acknowledgement that what happened wasn't invisible, that it was seen, that it was recorded, and maybe that it was ignored. One lawyer put it simply: they don't want revenge. They want to know if the system failed them or chose not to see them. That question hangs over every sealed page. If these documents show that alarms were raised, then the story isn't just about a criminal. It's about a gap between knowledge and action. And that gap has a human cost. Every withheld document delays closure. Every redaction extends uncertainty. Every excuse feels like another locked door. That's why this moment feels heavier than a legal deadline. Because it's not just the FBI being tested. It's the idea that truth belongs to those who were harmed. And if the system cannot release history, it cannot claim justice. December 20 isn't symbolic. It's operational. On that day, one of three things happens. The FBI complies, fully or partially. The judge rejects their reasoning and orders release. Or the Bureau resists. Each path carries consequences. Compliance means exposure. Resistance means confrontation. Delay means escalation. And judges do not escalate lightly. If the court finds the Bureau's explanations hollow, it can impose fines, sanctions, even contempt. That's rare. It's also revealing. Because it tells the public something institutions try to hide, they are not above oversight. This case may become a blueprint, a signal to other courts that secrecy must be justified, not assumed. And once that precedent exists, it spreads across agencies, across cases, across decades of archived silence. That's what makes this dangerous for power. Because once a system proves it can be forced to explain itself, the illusion of permanence cracks. The files may arrive redacted, they may arrive slowly, they may arrive incomplete, but arrival itself changes everything. It tells survivors they were not forgotten. It tells journalists that persistence matters. It tells institutions that silence has an expiration date. And it tells the public something even more important. That truth doesn't disappear. It waits. Sometimes for years. Sometimes for decades. But when the clock finally runs out, it speaks. Every institution leaves fingerprints, not on doors, on paper. Inside those sealed pages are timestamps, signatures, email chains. They don't just show what happened, they show who knew. That's what terrifies systems built on discretion. Because documents don't forget, they don't reinterpret, they preserve intent. Legal analysts believe these files may reveal how early warnings were classified, rerouted, or quietly archived. Not destroyed, just buried. And buried records create a unique kind of liability. Because they prove the absence of ignorance. A mistake can be forgiven, a delay can be explained. But knowledge without action becomes a choice. The judge's order forces that distinction into daylight. If the FBI claims harm from release, it must now show how. Vague language won't survive. Each page must justify itself. This transforms secrecy into evidence. Every redaction becomes a claim. Every withheld line becomes a hypothesis. And once hypotheses enter a courtroom, they invite challenge. This is no longer about privacy, it's about whether silence was policy. Institutions don't fear truth, they fear interpretation. A memo taken out of context, a note misunderstood, a warning that sounds louder in hindsight. That's why agencies cling to control. Because once records leave the vault, meaning escapes, and meaning is unpredictable. A single sentence can reshape public memory, a footnote can reframe history. This isn't paranoia, it's institutional instinct. But instinct isn't law. The court understands that secrecy protects more than operations, it protects reputation. And reputation is not a lawful exemption. Judges exist to separate risk from discomfort. If release creates embarrassment, that's not harm. If it creates accountability, that's not danger. It's consequence. And consequence is what systems avoid most. This case isn't unfolding in silence. It's happening in a world that archives everything. Younger audiences don't remember a time when institutions went unquestioned. They grew up watching footage surface, files leak, histories revise. To them, secrecy feels outdated. They don't ask, why release? They ask, why hide? This generational shift matters, because trust is no longer automatic. It's earned, and earned through visibility. For many, this deadline represents something larger than Epstein. It represents whether authority still answers when challenged, not in speeches, in documents. If these pages stay buried, cynicism hardens. If they surface, even imperfectly, a signal is sent that systems can still be compelled. And that matters. Inside every agency are people, not logos, not titles, humans who join believing in purpose. Some of them now watch this moment with conflict. They know what transparency costs. They also know what silence erodes. Careers can survive error. They don't survive betrayal of principle. Quietly, some hope the judge wins. Because when courts intervene, responsibility shifts. Blame moves upward. Conscience finds shelter. Sometimes people wait for authority to force them to do what they already believe is right. History shows that reform often arrives this way, not through courage alone, through structure. Deadlines change behavior. They compress excuses. They expose priorities. As December approaches, every hour becomes weight. Lawyers refine language. Officials rehearse explanations. Systems calculate risk. But beneath the strategy lies something simpler. Once files open, they cannot close. Once words are read, they cannot be unread. That permanence frightens power, because power thrives on reversibility. A statement can be revised, a policy can be reframed, but a document endures, and endurance is the enemy of denial. This moment isn't dramatic because of what might be revealed. It's dramatic because of what can no longer be erased. The clock is moving, and history is leaning forward. Courts don't just decide cases, they shape behavior. Every ruling becomes a message to institutions. This is how far you can go. This is where the line is. If the FBI succeeds in resisting this order, other agencies will learn something dangerous, that time and complexity can outlast accountability. But if the judge prevails, the message reverses. It says secrecy must be defended, not assumed. It says archives are not immune. It says even the most powerful institutions answer to law. That's why lawyers across the country are watching. This isn't an isolated battle. It's a template. A victory for transparency here echoes in future courtrooms. A loss teaches silence how to survive. Precedent is invisible power, and right now, it's being written. Even when documents are released, they arrive wounded. Black bars. Missing names. Gaps where meaning once lived. But redaction tells its own story. What is hidden reveals what matters. A page with one line removed speaks louder than a blank page. It signals sensitivity. It suggests priority. It invites inference. Readers don't just see what remains, they study what's gone. Patterns emerge, and patterns build narratives no agency can fully control. That's why partial transparency still changes everything. It teaches people how to read between lines, and once people learn that skill, silence becomes loud. Every system claims purpose, but purpose is measured in outcomes. For survivors, the question is simple. Were we invisible or inconvenient? If warnings existed, if reports were filed, if concerns were logged, then harm wasn't unseen. It was deferred, and deferral has a cost. Not abstract. Human. The files may never answer everything, but they can answer one thing. Did someone try? Because trying matters. It draws a line between failure and neglect, between tragedy and choice. And for those who lived in the shadow of delay, that line is everything. This moment also tests journalism, not the chase, the follow-through. When documents surface, they won't speak plainly. They will require patience, context, restraint. It's easier to amplify shock than to build understanding. But real accountability isn't spectacle, it's clarity. Every outlet will face a choice: exploit fragments or assemble truth. The difference defines trust, and trust defines whether transparency heals or merely entertains. Power thrives when unseen, not because it is always corrupt, but because it is unobserved. Witness changes behavior. That's why courts exist, why records matter, why archives threaten. A sealed file is power without witness. An opened one becomes history, and history resists control. Once recorded, it belongs to everyone. That transfer, from vault to public, is what this deadline represents. Not exposure. Transformation. Agencies remember differently than people. They remember through policy, through protocol, through precedent, but they forget emotion. They forget harm. Documents restore that dimension. They reconnect decisions to consequences. They force institutions to confront the human shape of their choices. That's uncomfortable. And necessary. Because memory without feeling becomes repetition. And repetition becomes culture. Every turning point feels quiet before it breaks. There is always a moment when nothing seems to happen. Phones don't ring. Statements stall. Systems pause. That's where this case now sits. In the stillness before motion. Behind that stillness, strategies collide. But beyond strategy waits something older than policy. Truth. Not dramatic, not loud, persistent. Deadlines are not about time. They are about courage. They ask institutions whether they believe in the rules they enforce, whether law applies upward, whether transparency is principle or performance. December is only a date. But dates reveal values. They show what matters when delay ends. Somewhere, a survivor watches the news, not for drama, for recognition, not for revenge, for acknowledgement. They don't need perfection. They need proof that their pain was seen, that it mattered enough to be written, that it mattered enough to be remembered. Justice begins there, not in punishment, in truth. If the pages open, they will not roar, they will whisper, through margins, through footnotes, through dates and decisions. They will tell a story not of monsters alone, but of systems, of pauses, of deferrals, of moments when power chose comfort over urgency. And in that story is a lesson older than any agency. Silence protects until it doesn't. Truth waits, and eventually, it demands a witness. This deadline is not about documents. It's about whether history belongs to those who control it, or those who lived it. When the files breathe, we will learn the answer.